So another Second Amendment case is up for Supreme Court consideration because the Second Circuit refused to follow the Supreme Court's prior unanimous decision which barred warrantless search and seizure of firearms within a home. So let's talk about this. How's it going, everyone? My name is Anthony Miranda. I am a licensed and practicing attorney in the state of California with an emphasis on Second Amendment rights. I've been part of Second Amendment litigation both at a state level and a national level while serving as a staff attorney with the Firearms Policy Coalition legal team. My goal with these videos is not to provide any legal advice, but instead to give you insight into the inner workings of Second Amendment litigation and what is currently going on in the Second Amendment realm. As I mentioned in the intro, in this video we will be discussing a new case which has been distributed to the Supreme Court for consideration. This case deals with the unlawful search and seizure of firearms by police without a warrant in a man's home. The case we're going to be talking about in this video is Torcivia v. Suffolk County. This case is similar in nature to another Supreme Court decision that we've talked about on this channel in the past, and that is the Coniglia v. Strong case. This case, Torcivia, is a lower court decision that flies in the face of that prior Supreme Court decision, which stated that the permitless and warrantless entry of a home under the whole community caretaking exception is in fact unconstitutional. The plaintiff in this case, Mr. Torcivia, is now seeking for the Supreme Court to review his case and for the Supreme Court to correct the Circuit Court's defiance of their prior unanimous decision. The facts surrounding this case, Torcivia, are actually very interesting. Wayne Torcivia is a 57-year-old man who has no record of violence, no history of suicide attempts, depression, or any mental health issues. Early in the morning of April 6, 2014, his teenage granddaughter called social services, complaining that her grandfather was yelling at her and was acting weird. Following the call from this granddaughter, the social services contacted Suffolk County Police Department, which then sent 3 police officers to his home. When the police officers arrived at his home, they all agreed that he had not committed any crimes and that the granddaughter's complaints were absolutely false. However, at one point during the discussion between Mr. Torcivia and one of the officers, this police officer turned slightly and accidentally knocked down a magnetic drape that was attached to his front door. As Mr. Torcivia went to then go pick up that magnetic drape that fell on the floor, the officer then screamed at him very loudly and told him to get back and also threatened to tase him if he did not get back. Mr. Torcivia then claims that he then responded and told the police officer not to tase him because he has a heart condition and that he could die. But the police officer alleges that he heard that Mr. Torcivia said that he in fact wanted to be tased and that he wanted to die. In reaction to that, the police officer, hearing that, decided that he needed to handcuff Mr. Torcivia, and then later Mr. Torcivia was transported to a psychiatric hospital. And from here is really where everything spirals out of control. After dropping him off for a psych evaluation at the hospital, one of the officers then learned through a computer check that Mr. Torcivia had a New York State pistol license and therefore also had firearms within his home. That police officer then contacted his sergeant, who instructed him to ask Mrs. Torcivia for the guns, and if unsuccessful, to then return to the hospital to get consent to seize the firearms from Mr. Torcivia. However, both Mr. and Mrs. Torcivia denied the police consent to actually seize those firearms. Eventually, Mr. Torcivia's psych evaluation came back clear, and 12 hours later, he was recommended to be discharged. However, a social worker on the case then found out about this and told her intern to get the combination to the gun safe. The intern then called Mr. Torcivia's wife and said that there was a change of plans and that her husband would not be released until the firearms were given up. The social worker intern also then called Mr. Torcivia and told him that he would not be released until the firearms were confiscated. And because of this, eventually Mr. Torcivia gave to the pressure of being held in the psych hospital for essentially forever and did decide to provide the combination to the police officers so they could get into a safe and confiscate those weapons. Then later down the road on May 6, 2014, Mr. Torcivia requested the return of his firearms from the police. His pistol license was later revoked, and although there was a hearing over the loss of his license in late 2015, he has never recovered his handguns. And it took over 2 years for the department to eventually release the long guns to a gun store, who then were able to transfer them back to Mr. Torcivia. So those are the basic facts surrounding this case. This issue spiraled from a baseless call from a teenage granddaughter all the way to him being held in a mental health facility and being threatened to not be released ever until he gave up his firearms. This case made its way up to the Second Circuit for review, and on review, the Second Circuit found that under the special needs exception to the warrant requirement, the police officers in this case were able to engage in this type of conduct. In reaching that ruling, the Second Circuit largely ignored the recent Supreme Court unanimous decision in Coniglia v. Strom. Now, if you're not aware, last year the Supreme Court issued a unanimous ruling in the case called Coniglia v. Strom. That case dealt with whether the community caretaking exception that applied to vehicles could also then be extended to warrantless searches of homes. Coniglia made its way eventually up to the Supreme Court, and the Supreme Court issued a unanimous decision in favor of Mr. Coniglia. Justice Thomas, writing for the majority, stated in that opinion that the Fourth Amendment protects the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The very core of this guarantee is the right of a man to retreat into his own home and there be free from unreasonable governmental intrusions. Justice Thomas therefore found what is reasonable for vehicles is different from what is reasonable for homes. Katie acknowledged as much, and this court has repeatedly declined to expand the scope of exceptions to the warrant requirement to permit warrantless entry into the home. Now, going back to this case Torcivia, the petitioner here seeks a summary reversal by the Supreme Court because the Second Circuit outright refused to apply the Coniglia decision, which the Supreme Court just issued. He states in his petition that, as in Coniglia, there was no dispute that the exigent circumstances exception did not apply. Indeed, this case is even clearer than Coniglia, and the Second Circuit's efforts to distinguish it constitutes the plainest of plain error, if not an outright resistance to this court's authority. Because of the direct violation of the Supreme Court's precedent, he argues that and requests for the Supreme Court to grant a summary reversal, which is a very harsh remedy available to the Supreme Court that the Supreme Court can actually use if they find that a lower court is directly and outright refusing to apply and adhere to prior precedent. Now, this case Torcivia was just set for Supreme Court conference, which will take place on November 10th. At conference, the justices review the case. They vote on whether or not they want to grant cert in the case. For cert to ultimately be granted, there needs to be at least 4 justices who vote in favor of taking up the case. At the conference, the Supreme Court could also deny cert, or in some cases, they also hold the cases and reschedule them for a later date. This case is important like Coniglia because it deals with your protection against search and seizure of firearms within your own home without a warrant. The Supreme Court tends to like warrantless search and seizure cases, and so this case might actually entice the Supreme Court to take up a similar case like they just dealt with, which was the Coniglia case. Also, like I mentioned, they can do the whole summary reversal. That's another option they have. But we will have to wait and see ultimately what they decide to do. However, what this really boils down to in my eyes is that it really doesn't matter if a search or seizure is done under the guise of community caretaking or the special needs exception. The reality remains that we as US citizens and gun owners don't want police officers to be able to come into our homes and search and seize firearms without a warrant under whatever exception or whatever basis they claim. Whether it's community caretaking, a special need, they just want to check on us, whatever it is, we don't want them entering our home without a warrant. Hopefully the Supreme Court takes up this case, but if we get any more information, I will let you all know. If you have any questions, go ahead and comment down below and I'll try to answer best my ability. You can ask me questions like someone recently on my last video asked, how early is too early for Christmas decorations and Christmas songs? In my opinion, I'm one of those people who really likes Christmas decorations and Christmas songs. So as soon as November hits, I'm all for it. But I know some people are different. So let me know down below in the comment section, where are you at on that? Do you like Christmas songs before Thanksgiving? I know some people say once Thanksgiving's over, okay, yes, then you can have Christmas songs and decorations. But I'm one of those people that I like it as early as possible because Christmas is my favorite holiday. Also, if you like this video, like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signal to YouTube that you guys see value in these videos and in this type of two-way news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.